Okay, everybody, welcome to session 175, Navigating Employment Issues When Dealing with Thyroid Cancer. My name is Daria Gerald, and I am going to be your host today. I'm so pleased to announce Nicole Jolicoeur, Esquire, attorney. She is a cancer rights attorney at Triage Cancer Center in Chicago, Illinois. Nicole has a passion for assisting those diagnosed with cancer. She appreciates and shares Triage Cancer's mission to provide education on the practical and legal issues that those diagnosed with cancer may experience. Prior to joining Triage Cancer, Nicole was an Excelsior Fellow at the New York State Office of Mental Health in Counsel's Office. Welcome.
Thank you very much. Okay, so I am here to talk to you all about navigating employment issues, and I'm a staff attorney here at Triage Cancer. So for those of you who haven't heard of us, I think it's just helpful to understand a bit more about what we do. So we're a national nonprofit, and we focus on providing free education on the legal and practical issues that impact individuals diagnosed with cancer and their caregivers. And because today is going to be a broad overview of several topic areas, I want to let you know a little bit more about our resources that we have because it's where you can go to find additional information. So all of our resources are for free and they're on our website at triagecancer.org. And we understand people learn in a variety of different ways. So we have written materials such as our quick guides and checklists that provide you a brief introduction, all the way up to our more detailed information in our practical guides or our toolkits. We also understand that not everyone learns through reading, so we have brief animated videos that provide introductions as well as monthly webinars that we record and archive on our website. And we also have a few conferences a year. So I want to start by acknowledging that this particular topic is certainly not a one-size-fits-all scenario. So when we talk about individuals experiencing side effects and treatment, it can really vary in terms of when you're experiencing your side effects, what side effects you're experiencing, as well as the severity of those side effects. And so while I might revert just for like ease of discussion throughout the presentation to during treatment, a lot of what we talk about is not applicable just during treatment, but throughout your experience, as long as you're experiencing side effects. So today we're going to cover a lot of ground in a short amount of time. So we're going to talk about essentially three main areas. We're going to talk about taking leave from work, working through treatment, and then disability insurance, because sometimes, despite people's efforts, they need to take some time off, and typically people need to supplement their income. So a lot of our conversation today really starts around battling assumptions. So we see this in a lot of contexts, but particularly in the employment context. So we talk to people who are like, no one ever asked me if I wanted to work. They just told me to go off of work, and I don't know if I can work, and I don't know what's available, but I would like to work, right? So we really want people to feel comfortable in their decision. And part of that is understanding all of the options and laws available to you so that you can navigate based on your wishes and maybe kind of challenge some of the people in your lives' assumptions. So when we talk about employment rights, there are actually a lot of places to go. So first are fair employment laws, and these are laws that protect people from discrimination in the workplace. These are available both at the federal level, which is the Americans with Disabilities Act, as well as state and sometimes local laws. And we'll talk about why that's important in a bit. There are also leave laws that provide job protected leave for individuals when they need to take time off. And then people often forget that they may be under an employment or union contract that may have additional protections or rules that need to be followed. So we always refer people back to that if they operate under a contract. But just because there are federal laws out there or state laws out there, it's really important to understand that that's the floor that your employer has to follow if they fit under those rules. It doesn't necessarily mean that's the maximum amount of benefit you're going to get from an employer. So some employers will have protections above and beyond what we're talking about today. And the way you find that out is usually in your employee manual, or HR might have certain processes. When we talk to people about this, they're like, great, but how do I know more about it without disclosing to my employer why I want to know more? We're actually in a pretty good time right now. A lot of the fall is typically for employers' open enrollment for different benefits. So we think it's a great time for people to approach their employer and neutrally just say, I'd like to know what all of my options are now that we're considering open enrollment. Where can I go for this information? So the first thing we're going to talk about is the Americans with Disabilities Act as a fair employment law. Now, a lot of people know about the ADA and not because of employment. They've heard of it in terms of accessibility into buildings, public accommodations, and sometimes even in the education context. But today we're going to focus on Title I because it applies to employers. And it is enforced by the Equal Employment Opportunity Commission. I will likely revert into saying EEOC a lot. That is who I'm referring to. It's because they have guidelines and they're responsible for making sure employers follow this part of the ADA. So in order to get protections under the ADA, you have to work for a private employer with 15 or more employees or a state or local government of any size. If you work for a federal employer, you likely have similar protections under the Rehabilitation Act. What we go through today will still help you with context to figure out what your options are. You also have to be a qualified individual. Practically, what this means, well, legally, what this means is you can perform the essential functions of your job with or without a reasonable accommodation. Very wordy. What it means is you're qualified for your position. You can do the job duties listed, and you could do it alone or potentially with help. And then you have to have a disability under the ADA. When I talk to people about the ADA, it really kind of upsets a lot of people because of the word disability. And this is one of the few areas where we urge people not to get too hung up in the language, particularly because the Americans with Disabilities Act definition of disability is very, very broad. So it is a physical or mental impairment that substantially limits one or more major life activities. Again, a lot of words that aren't helpful. Practically speaking, you have to have a condition that's substantial enough that it's not affecting you occasionally, it's affecting you frequently. And then it affects what's a major life activity, which is really anything that someone can do with little or no effort. So eating, breathing, sleeping, walking, talking. So typically, when someone's diagnosed with cancer, there's going to be something that's affecting them, whether it's the cancer diagnosis itself or symptoms or side effects that can make them fit under the ADA. And you're probably wondering, great, well, what is the benefit of the ADA? So there are actually 4 ways that people are protected under the Americans with Disabilities Act. And we're really going to focus on the first and second. So you currently have a disability or you have a history of disability. But it's important to understand that the Americans with Disabilities Act applies through all phases of the employment process. And that's not going to be the case for all the laws we talk about. So when someone's applying for a job, when they're interviewing for a job, as soon as they get the job, through hiring and firing decisions, this is an important law. And practically speaking, it prevents individuals from who have disabilities from discrimination in the workplace. It also can protect people who are regarded as having a disability, or in the instance of caregivers, having an association with someone with a disability. This is really important because practically speaking, what it means is your boss can't look at you and make assumptions that maybe you don't want that promotion because you're going through treatment or you're taking care of your loved one, because that would be a decision based on your disability or medical condition. Now, for individuals for individuals who have a disability or have a history of having a disability, you're not only protected from discrimination, but you have access to a tool called reasonable accommodations. And they are a super underutilized tool that can really help people continue to work through treatment. And so I don't find the definition to be helpful. I'm going to read it to you, but then we're going to talk about practically what it is. So it's any change in the work environment or the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. I know it's a lot of words. Practically speaking, a reasonable accommodation can be anything as long as it's reasonable that helps you continue to work. And so that looks like a lot of different things, but there are typically 3 buckets that it can fall under. So one is adjusting workspace. Oftentimes when I talk to people, they immediately jump to telecommuting or working from home. And that may be an option, but remember you have to keep reasonable in mind. So if you're a bus driver, it's likely not reasonable to want to telecommute. But there are other really helpful things depending upon your side effects. It could be moving offices so that you're closer to a bathroom if that's needed, or away from the cafeteria if you have severe nausea. It could be special furniture requests, working from a different location that's maybe closer to your treatment facility or closer to your home so you have less of a commute. Then there's adjusting work schedules. So this can be very, very different depending upon your needs. But for some people, it's starting earlier in the morning, or perhaps your employer only allows 1 half-hour break and you need a half-hour break and 2 15-minute breaks to recharge, or maybe you need an hour and a half to recharge. These are all potential things that could be accommodations. And then there are a lot of other options. So one potential accommodation that we speak to people a lot about is shifting job responsibilities. Because inevitably, when you work at a place for long enough, you get job duties that aren't essential to your role. So I think an easy example of this are teachers, right? So their main role is to provide education in whatever area they're in, but they inevitably end up with bus duty or lunch duty or some after school activity. And so if that's not considered essential to performing their job, that can be reassigned to someone else. There's also the potential for a reasonable accommodation of completely switching jobs within your employer. This is often referred to, though, as the accommodation of last resort. And here's why. First, your employer does not have to create a position for you. There has to be an open position. And the second part is they don't have to train you in order for you to be in that position. So you have to already qualify for the position. Practically speaking, what that looks like is you see the listing and the requirements and you meet those requirements. If you are eligible, then as an accommodation, you can change jobs. Just note that sometimes there's some pushback in terms of like other rules and things. And that happens a lot with accommodations where we hear a lot, well, my employer doesn't want to set a precedent. And the purpose of accommodations is that it's an exception to a rule, policy, or procedure because of your disability. I find it personally very difficult to think of accommodations because I am very not creative. So a helpful tool is the Job Accommodation Network. They're part of the Department of Labor, and they have a searchable online accommodation resource, or SOAR, where you can go on and you can look at your job duties that you're having difficulties with or the side effects that you're having difficulties with. And you can see what types of accommodations have been helpful to others. And so it can kind of start you on an idea path of what may be helpful to you. So while I've explained what accommodations are, we really haven't discussed like how practically do you go about this and really what's required of your employer. So often we get asked, well, does my employer have to give me a reasonable accommodation? And the answer is yes, unless 2 conditions, one of the 2 happen. The first is an undue hardship, which your employer is required to demonstrate it would cause, and it's a significant difficulty or expense to your employer. This is a really high standard. The EEOC has guidance on different types of accommodations and undue hardship. It's pretty easy to Google in case you're running into issues. Or it's a direct threat. So the harm can't be like potential. It has to be significantly likely and like imminent. Now, the other question that people have is if I request a reasonable accommodation and my employer has to grant one, they have to request my specific accommodation that I requested. And that's not necessarily the case. If you request, for example, a modified work schedule where you work 4 days a week and 1 day from home, Your employer may say, well, we'd rather accommodate you based on your job duties where you come in every day, but you do 2 half days from home. And that may be okay if it meets your needs. So it has to be reasonable and effective. And while caregivers aren't entitled to accommodations, it's something that is potentially worth asking depending upon your work environment, because sometimes employers are willing to accommodate because they want to keep employees. And so we often hear from people who haven't yet had the conversation with their employer, and they're very, very nervous that their employer will deny them because of an expense or because of the culture of their environment. And so the Job Accommodation Network has actually done a decent amount of research on this. And the cost of accommodations for about 49% of accommodations is $0. And a lifetime or one-time cost is about 43%, typically under 300. And a lot of employers actually contact the Job Accommodation Network on their own because they're trying to retain their employees. So I mentioned the 2 times when an employer can deny a reasonable accommodation. And so the first is a direct threat to harm and safety. And your employer has the burden to show this, right? It is not upon you. They have to raise this as an issue and show that there's a specific risk, and it has to be current, not speculative. So even when there may be a risk of substantial harm, though, your employer is supposed to consider whether that risk could be reduced by other types of accommodations. Now, undue hardship is a bit more complex. And like I said, the EEOC does have guidance, but here are some examples of, depending upon the situation, where undue hardship can be found. So now that we know who's covered and what examples of accommodations can look like, we really haven't addressed how to request accommodations. And the first thing to know is that as soon as you think you need an accommodation, you should be requesting one. Because if you haven't requested one and your job performance suffers, your employer may make employment decisions before knowing that this is something that you needed. Now, how do you ask and who do you ask? Well, interestingly, the Americans with Disabilities Act doesn't set out a formal process that employers have to follow. So this is really going to depend on your employer. Some employers will set out a specific policy in their employee handbook. If that's the case, it's helpful to follow it. It's probably going to be your smoothest way to go about it. If they do not, you can start either with your supervisor, if that's who you're comfortable with, or HR. Now, typically, your need for an accommodation isn't something that's like talked about in a break room, right? However, sometimes HR may have to move information down so that your supervisor knows you have every Friday off, for example, as an accommodation. Or your supervisor may need to clear with HR or someone above them this accommodations that you're requesting. Now, accommodations are really cool because they are not time limited and you can get more than one, and your needs may change over time, which is why the one thing that the ADA does lay out is that it's supposed to be an interactive process between you and your employer. So what that practically means is you shouldn't be going to your employer and asking for a reasonable accommodation and just getting no as an answer, right? It may be we don't think that accommodation is reasonable, or we don't think we can do that accommodation, but let's have a discussion of other ways we can meet your needs. Now, this is theoretically how it's supposed to work. And I got to be honest that we talk to a lot of people whose employers aren't quite sure how to navigate this. And unfortunately, it falls on you as the individual who's having the difficulties to be able to really start that conversation and be like, these are the things that I need help with. These are my ideas. I know that can be frustrating, but it's where we found that people have the most success. So there are a few things to consider when you're thinking about a reasonable accommodation. The first is, what are you finding challenging? And then how is it a challenge? So if it's accommodations can also be at home and at school, but for work, how is it impacting your work? And then what would actually make it better, right? Because that prepares you for the conversation you're going to have about accommodations. Once you're there, you can request an accommodation. What we really urge people to do, because a lot of times these are just conversations in person or on Zoom or on the phone, is get it in writing. And it doesn't have to be this formal, overwhelming thing. It could be as simple as sending an email to whoever you had the conversation with your understanding of what was agreed upon, because that does a few things. They can respond and say, no, you're wrong, and you need to have a more in-depth conversation. They could not reply, and then you have the information that you addressed it with them. Or they could say, yep, that's correct. The reason this is important is employers and their structure change a lot. So if you worked something out with your supervisor, but you get a new supervisor a week or 3 months or a year later, it's helpful to have this down. So I mentioned that the ADA provides protection to private employers with 15 or more employees. So what happens if you work for a smaller employer that isn't a state or local government? Most states have their own fair employment law. We track them on our chart of state laws, which is at the bottom of the page. And they are broader in a few different ways. So they may have a broader definition of disability. Some actually list cancer itself as enough to qualify. And then some of them cover employers with fewer than 15 employees. And this is what it currently looks like. So to read the chart, for example, I'm originally from New York, and so we have a fair employment law of 1 employee. But in my home state of New Hampshire, we have a fair employment law of 6 employees. So they do differ, and it's important to understand your state's laws. So if you live somewhere where it's easy to live in one state and work in another, like the Northeast, a lot of people wonder, well, what law applies to me? And I have a very frustrating lawyerly answer of it depends, and it can be very complicated. And there's a few reasons why. So it could be that your state law is more protected than the other state, and sometimes a court would find in favor of that. However, sometimes you have that employment contract or employee agreement or employee manual that actually lists which state laws will apply, right? So you want to check there as well. So while people are trying to work through treatment, there may be, or even post-treatment with significant side effects, there may be a time where they find they need to take time off of work. And so it's important to understand that sick, vacation time, PTO time typically isn't job protected. So what that practically means is if your employer thinks you're taking too much time off, you can be let go. And so this is where the Family Medical Leave Act, the federal leave law, comes into play. So this is a law not only for individuals with a serious medical condition, but individuals who are a caregiver for a spouse, parent, or child with a serious medical condition. And it's really only those 3 categories. You can't take time off under the FMLA for a significant other if they're not a spouse. You can't take time off to care for a sibling or an aunt or an uncle. It's just those 3. And so how are you eligible for the FMLA? So it's a bit complex. First, you have to work for an employer that has 50 or more employees or any government employee. Now, when I say that 50 number, a lot of times when I'm speaking to people, they're like, oh, it doesn't apply to me. And I'm like, okay, but like, do you work for a larger company? Yeah, but there's only 5 people in my office. There's actually a rule of a 75-mile radius. So if there are other offices in your area, you get to add them all up and see if they come to 50. So after that, you have to be working for that employer for 12 months and at least 1,250 hours before you need the leave. So the 12 months actually doesn't have to be consecutive. So say you worked for an employer for about 5 months, you left 3 years later, you come back and you've been working for them for, oh, I'm bad at math, 7 months. At that time, if you needed FMLA leave, you would be eligible as long as in that 7 months that you've returned, you've worked 1,250 hours. The 1,250-hour requirement does not include sick time, vacation time. It only counts hours actually worked. So what does the FMLA actually do for you? Well, it puts you in what we call an FMLA bubble. So it provides you up to 12 weeks of job protected leave per year. It is unpaid, but if you get health insurance through your employer, your health insurance is protected while you're on FMLA. So what I mean by that is if your employer pays part of your monthly premium, they have to continue paying that while you're on FMLA. So there are some ways to navigate the FMLA that are actually pretty helpful to know. So I talk to people and they're like, well, I don't need 12 weeks off, so I can't use it. You actually can use it in smaller segments of time, as well as intermittently. So say you have a side effect or symptom that kind of comes and goes and you can't predict when it is. You may be able to use it intermittently. So when you need that day off or that time off, it's job protected. Now, we also talk to people who are like, I'm very close to the end of my 12 weeks of time off. What do I do? And the answer first is find out how your employer calculates a year period, because it's not actually always a calendar year. Your employer can actually set any way to calculate a year period as long as they do it the same for all employees. Now, for ease of my brain, since we're towards the end of the year, let's say you're coming up on the end of your 12 weeks. If you have a calendar year plan, you know you get 12 more weeks as long as you've worked 1,250 hours starting January 1st. So it can be really helpful because it could get you some additional time. When you ask for FMLA leave, you are supposed to give notice if it's foreseeable. So if you know you have an upcoming surgery, you're supposed to do 30 days notice. If it's unforeseeable, it's as soon as practically possible, which with a lot of cancer issues, it's unforeseeable. So that's usually about 1 to 2 business days. Your employer cannot require you to exhaust your sick or vacation time before accessing FMLA. And that's because it prevents you from getting the protection under the FMLA. They can't require that you use your 3 weeks of sick time, your 3 weeks of vacation time, and then start FMLA because it prevents you from getting the FMLA protection. What they can do, and often do, much to people's frustration, is require you to use them concurrently. So if you start FMLA leave on March 1st, it's unpaid. They can require that you start your sick time on March 1st and run it out. If you would like to use your sick time, paid time off, you are also allowed to do that.
If you're a new employee and you're not, and you get a diagnosis, can your employer dig into your future, your next year holiday or whatever pay to cover your days in the current year?
Yeah, but FMLA leave is unpaid. So it's a separate issue from your sick and vacation time. So you're not going to access the FMLA without being there long enough. So it's a bit of a different issue, and I want to make sure I get through the other things. So while you're on FMLA leave, your employer can check in with you to make sure like your return to work plan is still on track. They just can't pressure you into returning sooner or things like that. So when we talk to people about employment, it is a very important time to talk about disclosure. And I'm not talking about disclosure to dissuade anyone from making disclosure decisions. We just feel very strongly that people should know what their options are and what their rights are under different laws. So if people want to disclose, that's totally fine. But if people are a little bit more quiet about what's going on, typically you don't have to disclose your medical condition to an employer. You may need to disclose some information to get the ADA protections or the FMLA, but that doesn't necessarily have to be your cancer diagnosis, because typically it's your side effects or your symptoms that are raising to the level of a serious medical condition or a disability under the ADA. And so when you're thinking about disclosure decisions for both reasonable accommodations and the FMLA, you typically have to fill out a medical certification form. And this is where, if someone is concerned about disclosing, we really suggest you start with your healthcare provider, because they do a lot of these forms and they don't necessarily think about disclosure. But when we've talked to them, they've said, hey, if someone doesn't want to disclose, then we can fill out the form in a way that doesn't disclose more information than necessary. We've even heard of oncologists who are like, I'll just write internist instead, right? So if that's something you're concerned about, that's something that you want to have a conversation first with them. The Americans with Disabilities Act doesn't have a model form for reasonable accommodations. However, the FMLA has a model form for certification for leave. And we actually suggest people use the Department of Labor model form, because employer forms may request more information than that's actually necessary, and your employer has to accept the Department of Labor model form. So if you're concerned about disclosure, it's an easy way to go. The one caveat is that your healthcare provider has to put their practice or specialization. So that goes back to having a conversation. And then if your oncologist is like, well, you can easily Google my name, then it's thinking about, okay, if I have severe nausea, maybe my regular doctor will be happy to fill out this form for me. Or if I'm having feet problems, my podiatrist, right? Like whatever it is, you may be able to make disclosure decisions. So employers cannot ask for copies of your medical records. They can't put your medical information in a regular file. And then for the FMLA, there are very specific rules of what they can do once they have that medical certification. So they can contact your healthcare provider to authenticate, meaning you really signed this form, and your healthcare provider can say yes. And then they can clarify, and clarify isn't, well, how bad is the nausea? It's, what's that word right there? I can't read it. That is the extent of the information they can request. The ADA is a little bit more unclear, but typically they can't contact your healthcare provider without your permission. There are also very specific rights when you are interviewing, as well as post an offer and once you're employed. And because we feel strongly about this, again, we have a whole quick guide on our website about it. And just to round out our conversation about disclosure, there are a lot of places where there are unintentional disclosures. So we see a lot of well-meaning family members that start a fundraising campaign. Just know a lot of those are Googleable, as well as if you're using your employer computer or email or voicemail. It's not to say that your employer is actively looking for this information, but sometimes when they're going through, they accidentally stumble upon something. And just remember, it's usually their property. So since the FMLA is so narrow and can be hard for people to qualify for, this is where understanding your state and county potentially leave laws is very important. So in a lot of states, there are laws for smaller employers, or they have an expanded definition of family. So you can take time off to care for your grandparent, your sibling, your aunt. And then they may have additional reasons why you can take that job protected leave. So we track this all on our chart of state laws in case you're wondering. Now, there may also be a time where individuals are unemployed, and so an option potentially may be unemployment benefits. I will say the process is very, very different depending upon the state you're in. And so we have information on our state resources page specific to each state. So this was a super brief overview of some rather complex topics. So just so that you are aware, we have a lot of information on our employment topics page that discusses this more in depth. And so I also want to spend a bit of time talking about disability insurance, because there may be a point in time where, despite people's efforts to navigate working through treatment or taking time off, that they are let go. And so disability insurance does not protect your job. That is something that people find surprising. It is only payment for being unable to work. and it makes up for your lost income, but typically doesn't provide 100% of your income. It's going to vary depending upon what we're talking about. And so there are a few different ways to get disability insurance. The first is through a private policy. There are short-term policies that are typically 6 months to a year. And then there are long-term policies that typically last a year or longer. These private policies, people typically end up with in two ways. They proactively purchased it on their own from a private insurance company, or it's offered as a benefit through their employer. I've talked to a decent amount of people who are like, there's no way I have that. And I suggest double checking with their employer, because when you first sign on, you sign a lot of paperwork, and sometimes employers will fully cover the premiums. So you kind of forget about it. And people have come back to me and been like, wow, I do have that. That's very convenient. So it's always worth a double check. Now, the issue with these types of plans is that if you haven't proactively purchased it, it's very difficult to get a plan after a cancer diagnosis, because they are not regulated by the Affordable Care Act. So you can be denied or charged more because of your previous or current health condition. And then even if you can get a plan, there's some things we suggest people double check. So your plan may say that you have to not get the same diagnosis again for another 5 years, or that you have to be actively healthy for 3 years before the plan will come into play. So it's just things and making sure you know your terms, which brings me to my next point. Private disability plans drastically vary. They vary on pretty much everything you can think of. So how does the plan define a disability? Is it just that you can't work in your current job? Or is it that you can't do your current job or any other type of work? What are the benefits? Are they paying you 40% of your salary? Are they paying you 90% of your salary? What does that look like? Do they have a waiting period before benefits start? This really upsets people, but it is common. So sometimes you have to be out of work for 30 days. Sometimes it's 90 days. What does that look like? How long do your payments continue? This really is one that we see big variation. So it could be a couple years. It could be all the way up to retirement age. It really depends. With the longer ones, sometimes that definition of disability changes after a few years. So it's just really important to understand the terms of your plan so that you can maximize the benefits and not have any surprises.
We have a question that came in online, and it says a lot of your presentation considers those already employed. Do you have any resources or references for those who are seeking employment, and in particular, someone just out of college trying to enter the workforce?
Yes, we do. So on our employment topics page, you're going to see a lot of things, but there is a section related to job searching. It's going to go through the things to consider when looking at an employer. So the size of your employer, what benefits do they offer, looking at their health insurance. We also have a quick guide to, I believe it's returning to work. I understand you're entering the workforce, but it addresses a lot of those rules about what can be asked in an application. If you need accommodations, what does that look like in the application process, in the interview process? What can be asked during an interview? Just so you know, your previous need for time off or your medical conditions are usually off the table. And then what can happen after an offer? So for the most part, you can't be asked to do something like a physical or for medical records unless it's asked for everyone in that position. So you'll find more information like that on our website. If you are looking for more help finding a job or even a resume review, there is a whole organization called Cancer and Careers that provides a decent amount of information and help on that as well. Okay, so if you don't have a private disability plan, and a lot of people don't proactively purchase them, what are your options? Well, if you live in one of 5 states, you may have access to a state disability insurance program. These are typically short-term disability programs. Most of them you pay into, so you can see it on your pay stub. And similar to private insurance, these operate very differently from one another. So if you're looking for more information about your disability insurance program, in your state, we have a state guide and we have more information on our state resources pages. And so finally, there are two federal disability insurance programs. Both are administered by the Social Security Administration, and they both have a very high standard definition of disability. So they look at, do you have a serious medical condition expected to last a year or longer or result in death? And because of that serious medical condition, you're unable to do your job or adjust to any other type of work. And that's the part that often wigs people out. How they differ is the other requirements. So for Social Security disability insurance, you have to have worked and paid into the system. The easiest way to check if you have enough credits, because your credits will be lower if you're younger, is to create a My Social Security account. It will have a nice little bar at the top that tracks your progress. It will also tell you how much, if you were to qualify for Social Security disability insurance, you'd get paid, because it's going to depend on how much you've paid into the system. And it will tell you how much roughly you would qualify for if you were to get retirement once you hit retirement age. Supplemental security income doesn't require that you worked and paid into the system. Instead, it looks at, do you have a low income and low resources? And low resources is very low. For an individual, it's less than $2,000. And resources are things like savings accounts, life insurance policies that can be cashed in. And it also looks at things that you get help from family, like your help with rent or food. So it's a pretty difficult program, but we have a lot more information on our website about both. The strongest thing to consider when you're considering applying for Social Security, while we talked about disclosure in an employment setting, when we're talking about disability insurance, you want to give them all of the information, no matter which program we're talking about, because it may not be your diagnosis itself that's impacting your ability to work. I know that sounds a little bit wild, but it's all the side effects, symptoms, and what we've experienced is people get used to certain symptoms and don't bring them up, or there isn't documentation of them. But when you're talking about qualifying for disability, they need to see the full picture, because when you add up all of those little things together, it can be what makes you unable to work. So I've talked about all of these things kind of in separate buckets, but they don't necessarily work separately. So I want to talk a little bit about why that's the case. So people may be eligible to take FMLA leave while they're on disability if they have a short-term disability. And the reason that that can be helpful when we're talking about finances is it gives you that job protection, but also that health insurance protection. So you're not paying COBRA premiums. And so it can help you, give you some time to know if you really need to be fully out of work or not. So I want to talk about how all of these can work together. And I think the easiest way to do that is through examples. So let's talk about Jane for a second. She went to the doctor and her doctor suggests that she goes out on disability. But she has 3 weeks of vacation, 3 weeks of sick time. Her employer is covered by the FMLA, and she has a short-term disability policy that, yes, could last her 12 months. But instead of going out on disability, she may have some options, right? Especially considering it looks like she's only going to need a short amount of time off, say 12 weeks. So if she needs that 12 weeks off, she could take the FMLA leave, which protects her job and her health insurance, but that's unpaid. So what practically could her options be instead of immediately going on disability, because it may be less than her typical paycheck? So she could do sick time for 3 weeks. She could do her vacation for 3 more weeks. The benefit here is you're getting paid at 100%. And then she can take that short-term disability for the remainder of the time off, which if she needed 12 weeks, is the additional 6 weeks to get her to 12 weeks. And then she's only lost some of her income instead of 12 weeks of her income. But I haven't really addressed what happens if you need more time than the FMLA provides you. And so let's say Mark has all the same facts as Jane, but he needs 15 weeks off. So I'm going to start on the payment side first. He could do similar to Jane, 3 weeks of sick time, 3 weeks of vacation time, and then do the short-term disability for as long as he needs for up to 12 months. So about 9 weeks would get him to the 15 weeks. But the FMLA only provides 12 weeks of job protection. And we talked about how typically after that, individuals can be let go in most circumstances unless your employer policy or contract says otherwise. Well, that brings us to the ADA. So we started with the ADA and reasonable accommodations. And another potential reasonable accommodation is taking time off from work. What is tricky about reasonable accommodations is what is reasonable in one job may not be reasonable in another. But there's been a lot of court decisions on reasonable accommodations and taking time off. Typically, it's going to be unreasonable if you don't have a set time period. So if you go to your employer and you say, I need additional time off, and you have no idea how long that is, it's typically not going to be reasonable. However, if you have a specific amount of time, depending upon your employer's needs and your job duties, it may be reasonable. Usually the less amount of time, the more reasonable it's likely to be. And so when someone doesn't have access to the FMLA yet, which I think we have been asked earlier, you may be able to request time off under the Americans with Disabilities Act as a reasonable accommodation so that you're taking that leave as job protected. When you take leave under the FMLA, it's considered job protected in that you're supposed to be reinstated to your position or a similar position. A similar position means usually equivalent job duties, pay, and benefits. Under the ADA, if you take time off, you're supposed to be restored to your exact same position. So it's always important to know which rules you're using because their protections will differ a little bit and how you navigate them is a little bit different. So does this make sense to everyone? So the important part of this really is to kind of go back to the beginning where each person's puzzle is going to look a little bit different. And how you put those pieces together is really about how you need them to work and what your goals are. So if you have a friend that's going through something similar, their options could look very different, whether it's because of their employer or the state they live in or what steps they feel are best for them to take. We just want to make sure that everyone knows the options available to them. So I gave you a very brief overview of disability insurance. If it's something you're considering, I really suggest you hop on our topics page. But also we did a webinar that was about an hour and a half long that really walks through what to consider when applying for disability insurance, but the majority of it focused on Social Security disability insurance and supplemental security income. So if those are things that you're having questions on, I would really start there. So my key messages for today are that it's really helpful to understand the broad range of options available to you so that you can put them together in a way that works for you, either to help you continue working or to have a minimal impact on your finances. And so that really comes down to understanding how to continue working if that's your wish, how to take job protected time off, really using your employer policies. Again, these laws that we talked about are the floor. Some employer policies provide way more protections, and it's helpful to know what those are. And then using disability insurance where available, and then understanding how to put it all together. So this pretty much the content part is done, but just so that you all know, if you go on our website, and you're like, oh my goodness, I've read and I still have so many questions, or I've listened and I still have so many questions. We are still here to help. We have a free program called our Legal and Financial Navigation Program. We will really talk to anyone who wants to talk to us. So whether that's your friend, your family member, because you're trying to like move things to other people, yourself, a healthcare professional, And what we do is we try to provide education. So we don't provide representation. We won't contact your employer on your behalf, but we'll walk through what's going on. We'll talk about what laws or rules may apply, practically how to navigate them. And our goal is to empower you to take next steps. The fastest way to get a hold of us, I promise, is not to call us. It is to complete our online intake form at triagecancer.org/get help. It's going to ask you a lot of demographic information because, not to sound like a broken record, the size of your employer, where you live, are all going to impact what options you may have. And then if you fill out the form and you give us an email, you're going to receive an automatic scheduling email to pick a time that works best for you to speak with one of us. And that is my spiel. So I am happy to take questions. Yeah, so it's going to depend on your employer's policy. So, the original question.
So for a brand new employee in government, who gets a diagnosis, like, let's just say within weeks of employment. So they do not qualify for FMLA. They do not qualify for short-term disability, and they have very limited PTO and sick leave. And they do have a program where you can borrow, or like employees can donate to other employees. Can they ask you to take, and they're trying to work with you, it's not a bad thing. Can they ask you to dip into the next year of like holiday pay? So you don't have any holiday pay, you have limited, you're only acquiring it as you're there. It's the end of the year. So there's not much available to cover like an extended leave. Can they ask you to dip into next year?
So it's going to depend on their policy of if that's something they do, but it's not going to provide you the job protection, right? It's only going to provide you the payment. So it really depends on the employer policy and kind of what that looks like, right? They can't have, if two people are sick, right? They can't make one person do it that has the same circumstances and not another, right? That's where you'd get into something like if it's a federal employee, the Rehabilitation Act or the Americans with Disabilities Act, because you're treating one person differently than the other due to a disability. But if they have a policy that they enforce across the board, that might be okay. Well, thank you guys for joining.
Okay, folks, we're wrapping up and just want to say thank you for an awesome presentation, and we learned a lot. Thank you.